To vet and perfect legislation, and we're going to continue that hard work in this committee today. We got a good little bit to get to, so we're going to try to move expeditiously. I'd ask Senator Jackson, if she would, to open us with a word of prayer.
Let us pray. Loving God, we give you thanks for this day. We thank you for the rain that waters our crops and allows us to be able to eat. We pray for all who work outside, for those who farm and pick and truck, so that we might all have food on our table. We ask that you would bless each of us. Amen.
Thank you. Amen. All right. First on the agenda, it's Senator Payne of the 54th, Senate Bill 512. And we've got I believe, a late arriving committee substitute in the file. So give us your LC number so we can be sure we're singing off the same page.
Yes, Mr. Chairman. The new LC is LC 393371S.
Okay. All right. The floor is yours.
Thank you, Mr. Chairman. We were here just a week or so ago with this bill, and we've made the change. There was a lot of discussion on the committee and a lot of concerns, and we feel we've addressed those concerns in this new bill. We've literally done away with the word animal, so it's no longer animal fighting, but it's just specifically to fighting of dogs and gamecocks. And so, and that is also defined on the second page as far as gamecocks mean a domesticated fowl that is bred, reared, and trained for purposes of fighting with other fowl. This also has provisions for the possessing the materials or the transportation of such materials for cockfighting, and also we've gone back and made it be closer to what the underlying bill was regarding dog fighting that it just now would just have for gamecocks and having birds to fight. And so that's pretty much all we have. I would say that the polling is 100. I mean, over the top on this. The people are for this. I know that's, and when you really break a lot of that polling down, it's the generational thing that you'll realize that jumps out at you as those. The older folks don't see a big a deal with it, but if those 40 and under, it's so that just kind of shows you eventually this is going to go away, and just because. But at the same time, as I said in the last meeting, I think it just really boils down to, violence does beget violence, and I think that just as I also presented during our last meeting, there was not too long ago that had just last year. A meth lab was busted by the state officials, and then in the possession of that during that bust, they also found cockfighting related materials and the cocks on the grounds, and so this is all intertwined with that criminal network. So it's literally just trying to take away some of that would be a funding source for them. Senator Hatchett also had brought up some concerns on the legislation in the last committee meeting, and we also have addressed that in this latest LC also.
Mr. Chairman, thank you for working with us on this. Dog fighting is currently illegal in Georgia already. This is just making some updates to that existing code and including cockfighting in that. Is that correct?
Yes, sir.
And it's narrow, and the language has been narrowed down to where we don't unintentionally capture any kind of hunting.
That's why I asked for a hearing in the last committee, just because that's why I asked for just to have a hearing on the last committee meetings, because I want to make sure we got. And I think we did narrow this down substantially to where we're getting to the crux of the matter we're trying to get to, and only that matter.
All right. Any questions for the author of the bill? Yes, or what? Mike, number 10.
Yes, sir.
Go ahead, Senator.
Just got two questions, really. I was reading through the bill here, and it says the court, as part of the sentence, may prohibit the offender from owning, possessing, or exercising control over an animal
What line are you on?
I'm sorry, line 42, 43.
Okay.
So I guess I'm just for clarification, if you've got a 12-year-old girl that's got a dog and her dad is, caught fighting dogs, the judge could take away that child's pet, is that right?
Well, the last bill, that was another change we made because it said shall, and we've changed that to a may. The court still has that discretion, but a judge will basically, who's hearing the evidence will make that call whether or not that person should not have any access to.
Okay, and just one more question. When it comes to line 59, any person who knowingly possesses, purchases, or sells fighting-related objects with the intent, I'm just curious, it says with the intent that such objects be used in promoting, facilitating, training for, and it goes on from there. Are there any, I'm sure you can give me some clarification on this, but are there any kind of material or things that a regular dog trainer, that it could be misconstrued, that this guy's training this dog for bird hunting or whatever else, that it could be possibly misconstrued to be using to be trained for dog fighting?
Well, this regarding to dog fighting or gamecock fighting, and so I think it's pretty evident when you're training an animal or teaching them to kill, two different things, and I think that's pretty evident. If any law enforcement officer would see that.
Okay.
And it does say with the intent. So if they possess it, that doesn't, the way I read it, I'm not a lawyer, but if they possess it, that doesn't necessarily mean they're in violation, but if they possess it with intent to train the animal for fighting, dog or gamecock fighting. That's the way I read it.
That's the way it does have that with the intent. It has to have the intent. So the intent has to be there that they're going to do this.
Okay.
Not just possess it.
Senator Hatchett.
Thank you, Mr. Chairman, and thank you, Senator, for working with us on the language. I know during the last meeting there was some hesitation in the provision that Senator Goodman just brought up about owning or having any control over an animal. We thought that may be too broad, and so just to be clear, this limits it to the species, either dog or gamecock, that you were convicted of fighting originally, and it's still up to the court's discretion whether or not that should be implemented.
Yes.
Okay, and then I just wanted to piggyback off of Chairman Goodman as well. Intent is a big part of that subsection E, where you have to possess it with the intent of training a dog to participate in these fights.
And anyone in law enforcement tell you that's a high bar standard, because trying to prove intent is, it's not something that's easily proved, and they're just going to be throwing everybody in jail over because they have possession of materials.
Right.
That intent, it puts it a very high standard.
And it was, no pun intended, but your intent to make it that high standard to protect people who may be training dogs for hunting or other.
Absolutely.
Thank you, Mr. Chairman.
Thank you. Chairman Anderson, you got a question?
Yeah, Senator, I'm kind of coming off what Senator Hatchett said. The intent, I guess, would be determined, say if you was training dogs to hunt wild hogs, or if you had dogs that you was training to catch wild cows that you cannot get up. I mean, cowboys use the dogs to help them catch cows that they get out and get wild. Where in the bill does that protect them?
Where in the bill does it protect what?
The dog that is trained to for hog hunting, and for a dog that's trained to catch wild animals that can't be caught.
I think the protection is in that word, the intent. The intent is that you're promoting, facilitating, or training for or otherwise participating in an exhibition of dog or gamecock fighting. And so if that's not there, then someone is raising dogs or training dogs for hog hunting, then they're not going to be in that. There's no way that they're going to be in that realm of possibility.
Okay, thank you.
Adding to that a little bit, the way I read it is online, in existing code on line 24, it talks about owns, possesses, trains, sells a dog with intent to be engaged in fighting with another dog. So that it's not, a dog fighting with a hog or fighting with a raccoon or something like that. And then on line 3, on line 28, number 3, they use the same language of gamecock fighting with the other fowl. So I think that makes it clear that we're not talking about hunting dogs.
And that new language is basically mirrors what was already in the language regarding dogs. So we're just taking that.
Our resident committee attorney, would you concur with that?
Yes, Mr.
So Senator Hatchett, would you concur with that?
I would. I think the changes in the law specifically are about the gamecock, and anything related to dogs is already in current law. So I think your concerns with hunting dogs, it shouldn't be an issue.
Dave, you want to speak to that, our other attorney?
Yes, sir. That's my reading as well, Mr. Chair.
All right, Chairman Anderson, another question.
One follow-up question. Is it nowhere in this bill is against the law for a bulldog to whoop up on a gamecock?
No, sir.
All right.
And when it comes to Athens, we really hope it happens. So.
Senator Andrew Jackson.
Mr. Chair, at the appropriate time, I'd like to make a motion.
Okay, go ahead.
I'd like to make a motion to pass.
All right, we have a motion to pass and a second from Senator Hatchett. Any further discussion? All right. Okay, yes, sir.
I think Senator Goodman kind of alluded to this earlier, and it's in that provision on lines 42 through 46. The term exercising control, I think I know what it means to own, I know what it means to possess. Is there anywhere in the code that Senator Hatchett, maybe to you, or is there, how would that be viewed, the term exercising control?
We may need to get legislative counsel, but the way I would read it would just be, I guess, in the instance where if you were an employee on a chicken farm or something like that, I think.
And I guess that's where I'm heading. So that's you actually brought up a scenario that I was going to present. The scenario is, let's say I own a chicken farm. Let's say my employee gets, one of my employees is charged under this code section who works for me on said chicken farm. And so can that employee no longer be employed by me and work on my chicken farm because of this one provision if the court imposes this sentence for 5 years? Because arguably my employee doesn't own them, that he doesn't possess them, he or she, but he could exercise control over my flock and over my poultry flock. So there's an argument that could be made that with a liberal view of that term, exercise control, that my operation, the employee that works for my operation could violate this court provision. Does that make sense?
Mm-hmm.
But I guess my question would be, is there anything in the law that would define what that means?
And that's the greatest sense is why we have that may
Yeah,
because to give the court discretion
And
to understand if it's just an employee at the
And I
chicken farm.
understand the may, I think, but the court could still impose the sentence. And if the court imposes the sentence for 5 years, I think that's the, for up to 5 years, I think is what it is, if I remember it right, for a period not to exceed 5 years. So poultry, you know, we're the #1 state in the nation when it comes to poultry. Actually, we would be 7th in the world if we were our own nation in production of poultry. I guess so. There are a lot of employees that work for poultry operations across the state. I think what I guess my question is does that term exercise control, would that apply to my employee who works for my operation? Because arguably they do exercise control over my flock in some way.
All right, let's check with the attorney on that. Just a minute.
Mr. Chair, I don't believe that there's a formal definition of exercise control in the code. That being said, I think that it would go to that situation, at least depending on the situation. So, for instance, your accountant probably does not have control over, it would not be exercising control over those gamecocks, but that somebody who is going in and out of the chicken house every day probably would be exercising control. But that would probably be left up to the discretion of the court, because I don't believe that there is going to be a formal definition of exercise control in our code.
Thank you, Dave. All right, so who knows about the species of chickens? Because I don't. I mean, is a gamecock a different species than a broiler or layer?
So, if I can, Mr. Chairman, the gamecock, as it relates to this code section, is actually defined to mean any domesticated fowl that is bred, reared, or trained for the purposes of fighting with other fowl.
Okay.
So I don't think it's limited to which species, but
I think on line 44 it says.
Wait to be recognized, please. All right, any other questions? Okay.
And maybe we can work on this going forward. I would like to maybe try to fix this. I think because I think there could be situations, because it specifically says within the species, and so I think if we limited it to gamecocks and dogs bred for fighting, because this is new code being added to the code section. I think if we limited it to that the judge had that discretion to do that. I think we clarify it, but it might take some significant wordsmithing to address it. I mean, I'd be happy to try to work on an amendment to address that, but I guess I'm just trying to. That species is a pretty broad term, and I think what Chairman Payne has done is significantly narrowed this down to address a lot of the concerns that were raised. Fortunately, I was not here at that meeting whenever y'all had that initial hearing, but I think we're still in this aspect. I still think it's a little broad, especially when you get to thinking about our states. You know, we're the #1 state for poultry, and I guess.
If we changed it to, excuse me for not following good protocol,
You're good.
but if we changed it to breed, would that
That's what I was just
change species to breed?
within the same.
I don't know enough
within the
about
same
chickens to know if
breed.
there's different
There are different breeds.
I might suggest offer any control over any gamecock or dog based upon the conviction of which, for which the conviction is based. So just instead of animal within the species, it would be exercise control over any dog or gamecock for which the conviction is based. Does that do that for you, Mr. Hatchett?
I think he was trying to, for the dog part, I think he was trying to use species so that if you were convicted for fighting a pit bull, but you wanted to own a Irish setter, you possibly could. I think is maybe the way why he worded it that way, but I don't know.
Dog is the
I
same
don't-
species.
What?
A bulldog would be the same species as a
Okay.
Irish settler.
Okay.
And I do like the wording. She's.
Can I,
Yes, sir.
Mr. Chairman, I think, and there may be a way to put an exception in here, in the control part, to basically say that, however, that the prohibition may not prohibit such offender from, as part of a normal agricultural operation, from exercising control over that species or something along those lines. Does that make sense, what I'm trying to do? No, I'm sorry.
So we have a motion and a second. This is a good discussion. I'm sure the author is amenable to working with committee members to assuage their concerns with that language. If you all were interested, we could go ahead and vote, considering we're up against the deadline, and it can, of course, be amended in rules or amended on the floor of the Senate. But if you're not comfortable with that,
I'll be
I don't
willing to work
intend to
on it.
have another committee meeting.
I mean, I'd be, if Mr. Chairman, if you're willing to work, I'd be willing to work with you to
Oh,
try to
absolutely.
come up with a, you understand the,
Yes,
where I'm going,
yes,
the
I
concern.
I do understand,
Yeah.
but I also want to just make sure that, you know, we're talking about that intent, that we're just making sure that, that person is not having.
And I understand your intent. I think there's a way that maybe
We're not giving them a loophole to be able to continue having.
And I understand what,
having those kids, those species.
I understand
in their
that.
possession.
I just don't want to have to fire an employee for 5 years.
Oh, I understand that. I do, and I'll be glad to work with you.
You good?
We can, if he's willing to work on amendment between now and the floor, I'd be willing to, because I think it'd take us a minute to try to wordsmith something to get it to where it's in a good spot.
Any suggestions, Dave? You don't have an amendment drawn up, do you?
I actually think I'm close. Mr. Chair, would be the court may prohibit the offender from exercising control, yada, 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 exercising control over any dog or gamecock based on the conviction for a period not to exceed. So striking animal within the species for which and is based, and then just reworking that sentence to be exercising control over any dog or gamecock based on the conviction. Yeah.
Well,
All right, hold on a minute. Sorry.
Gamecock, which is defined, is a domesticated fowl that is bred or trained for the purposes of fighting. So you can't include that because that's already illegal. If you're breeding a chicken to fight, and then you say the court can prohibit somebody from possessing it, I think you're going to have to keep it species because it's the chicken we're talking about. I understand the chairman's concerns, and there may need to be a carve out for if you're employed, but then, if your employee is abusing animals and taking away from the poultry the good reputation that the state has for producing poultry, do you really want him to have access to poultry? I think an amendment can be had, but I don't think including gamecock in the sentence is a good idea because
Okay. All right, so we got a motion and a second. Any further discussion? All in favor, please signify by raising your hand. Any opposed? All right, it passes unanimously. Thank you, Chairman.
Thanks, sir.
Good
And
luck
have a good
in
one.
rules, and
Appreciate it.
I'm sure you'll be hearing from some of our members.
All right, thank you.
Thank you. All right. Sticking with our theme of the day, we're going to hear Senate Bill 303. The esteemed Rules Chairman, Senator Mullis.
Thank you, Mr. Chairman, and apparently animal issues are somewhat complicated. I didn't realize that. I thought it'd be kind of easy scenario, but it's just not. And do you have another substitute handed to you that's got changes in it?
What I have in my folder is Senate Bill 303 LC 510151S. Or is there another one?
Well, the one I have is LC 510162S. Oh, I got. 0162S. The last few. And
I'm sorry, I was looking at the bill summary. So the bill summary hadn't been updated, so flip over to the actual bill, and it is LC 510162S. That's correct.
can I bring my friend up, Frank? He's lonely back there, and he can
Yes,
sit up here with me, Frank. And look, let me tell you, there's some rumors about me out there that are actually quite untrue, have been incorrect. So I just wanted you to know that. You figure that one out yourself.
All
Anyway,
right.
we'll move on.
We appreciate you working on this further, and
Thank you.
if you all would just tell us what changes you made since we last heard this bill.
Okay, if you don't mind, Frank, I've got this in front of me. Line 30 after shelters, we've added, but line 30, but shall not be included those who breed 1 litter a year and transfer ownership of those dogs. So we've reduced it. I think Senator Anderson was concerned about that. Line 80 replaces 7 with 10. Line 87 replaces 7 with 10 also. 87 and 80. 80, 87. I'll slow down if you need to, Counselor. Or Congressman, whatever. Number 80, it says replace 7 with 10. And then on number 87, the same. Replace 7 with 10. Line 91, Mr. Chair. After breed, insert, if known, line will read A in parentheses, the dog's breed, if known, comma, sex, comma, coloring, comma, and markings. That's line 91. Line 155 through 117. Striking these lines, age for age for transfer of a dog is the Department of Agriculture's rules and regs. I'm just going over the changes and then we'll talk. Line 119 replaces 7 with 10 business. Replaces 7 with 10 business. Line 128, I'm nearing the end here. Line 128, after the dog, add or $200, whichever is greater. Same thing on line 132, after dog, add or $200, whichever is greater. And line 135, after dog, add or $200, whichever is greater. I got one more or two more. Line 163, again, replace 7 with 10. And then 207 through 219, section 4-8-48, strikes the entire section. That's lines 207 through 219, sections 4-8-48. Strike entire section, which is registering of a dog is not part of making sure a healthy dog is sold. That's just the registration part. That's all the changes I have, Mr. Chairman, but I look for this committee's wisdom in what we should do
Okay.
for the future.
Those changes were incorporated and the lines were all renumbered.
Okay. Now you tell me.
But I think we get the gist of
Well,
so we had some discussion about 7 business days not being long enough, and
yeah,
you
okay.
changed that to 10, and made the other changes you went over. So,
Did you have anything to add, Frank?
Not really, Mr. Chairman.
Okay.
I think you covered all the changes.
Thank you.
We tried to accommodate the committee.
And look, we realize, and more so than ever before, what a complicated issue this is, that we're just trying to make sure healthy dogs and healthy dog mamas are taken care of in this process, and that we eventually get a routine of good animals in our pet stores. And I know the future, the Department of Agriculture looks great, and I commend the current Commissioner of Agriculture for all the work he and his team has done. But this issue is a problem statewide. It is in my district, and I appreciate Ms. Williams bringing it forward to me a while back. I just didn't realize it'd be so dang tough and complicated. So I'm up to the discretion of the committee where we go from here.
all right, Mr. Chairman, would you accept any questions?
Except from Lee Anderson. No, I'll be glad to.
All right, you do have a question from Chairman Anderson.
I thought that he looked like he was about to.
I hadn't been able to find it in the new substitute, but in the original bill, on line 48, we had sterilization of dogs before on no later than 5 years old. Why 5 years old?
We just felt that was a good starting point. Not sure.
I mean,
Frank, you got an answer?
I had a breeder
That asked you.
that got in touch with me over the weekend.
I'm sorry, Senator, what line was that? You said,
Well, it was in the old bill.
okay,
Oh, it's not
I don't have the
bad.
little one.
5 years old for a dog to do what?
Sterilization.
Sterilization. I'm not sure why we went there, but
Is it in this bill?
I don't think it's in this bill.
It's been taken out.
Has it been taken out?
I think it has, yes.
Okay.
And look, our intention was to, again, protect dogs. And I know whenever you create a bill, it goes further than sometimes what you're intending to do. So I found out that we've apparently gone that way, especially with my original bill. And I appreciate Frank and the Canine Coalition, especially out of good excellence, of being part of our, trying to find a solution for this.
Thank you, Mr. Chairman.
You're welcome, Mr. Chairman.
Further questions? All right.
It was in the original bill and it's in this one too, but in the definition of transfer, it also lists, the term giving away. So, if I just give a dog away,
Line 31, I think.
that's correct. Line 31 and 32.
Talk about transferring ownership of a dog.
That's correct, yeah. I'm then subject, the way I understand it, and this is without me reading the substitute, it's about, I don't know, about 10 pages, so it's hard to read something in a few
Yes, sir, I
minutes.
Tell me your gist, we'll
But
talk about it.
basically, the gist would be, at that point, if you took the dog to the veterinarian, then I would be responsible for those vet costs if you were able to exercise the rights under this provision. Is
Well,
that?
I'm sure that we wanted to, if you're gonna sell or give a dog away,
I can understand if
you
I
should
sold
make
the
it
dog.
safe, and, you talking
Yeah.
about they'll give, it should be their responsibility.
Well, I think it's one thing. I think it's one thing to sell a dog, or
So if it sells, you think it should be properly vetted, so to speak, with the
I
veterinarian.
mean, I think there's some room for that, yeah,
Yeah.
and I think that's what your underlying bill obviously does. But I think when you get into the process of when there's no exchange of financial of anything, then you can come back on me.
So you think if you give the dog away, you shouldn't be responsible
But
for
I guess I'm asking for clarity. That is, is what this does,
that-
correct?
Senator, that's the way I read it. I'm just thinking sort of out loud about it, that the whole approach was that we were going to make this a contract, enforceable as a contract, which it is. I guess if I go back to first year in law school, giving away is not a contract. It has to be consideration. It's basic law. I'm not sure it would hurt if this were stricken, giving away.
Yeah, you know, we're amenable to that.
Okay.
I could get me.
That's not what I understand. Thank you for
All right, Senator Hatchett.
Thank you, Mr. Chairman. And, Mr. Chairman, I would tend to agree with Senator Harper on this one when it comes to the giving away of dogs, just because, you know, I've been in the Walmart parking lot in Habersham County and people are giving away puppies, and I don't want it to discourage people who may not be able to take care of dogs from trying to give them away to homes that.
Senator, we're agreeable with you. Would be amenable to such an amendment to make sure that it's more like that. We want to make sure puppies and other animals have fine homes. But if you're selling them, don't you think they should be a little more responsible?
Yeah, I do think it should be limited to the selling.
We agree. We agree with this committee. A fine.
Any other questions? I think we have some people signed up to talk. Yes, sir. Senator Anderson.
On the giving away, I agree with Senator Harper here. Giving it away as long as it's a healthy puppy.
How do you know?
That's the, I just wondered that. I mean, that's kind of a gray area there. I mean, how do you determine whether to give away puppies healthy?
You'd have to have some kind of veterinarian provision in there, I would think. But we're willing to go past that if it's a giveaway. I mean, just like if somebody's giving you away, Senator, I'm sure it would appear to be completely healthy, but you just never know what could be around the curtain.
I understand. I think
I'd take you,
we
though.
need to have something in there about it's a healthy.
I agree. Thank you.
Well, thank you.
Yes, the speaker will step back.
Senator Summers, do you have a question?
Thank you, Mr. Chairman. Can you touch on the issue regarding dog rescue? There, in my area in down South Georgia, there are 2 in each town, sometimes 3 privately. Some of them are owned by the county, or not owned, but controlled by the county. And of course, there's fees involved. And then you may get a dog that you don't like from the county, or you may get a dog from a person who's rescuing dogs that you don't like. I mean, I know this one person who has like plus or minus 40 or 50 dogs at any given time, trying to find homes for them. Can you touch on that? How this might affect?
Well, to the extent they were being sold, consideration passing between the two parties, this bill would apply to them. If we take out the word give away, and if the rescue was giving them away, then it wouldn't apply.
I don't think any of them are free, because you have to have them either spayed or neutered, or you have to have the veterinarian inspection. So I think there's some cost there, but I'm not an expert on that. I just know there's some issues there.
I know usually when you get a dog from rescue, that part of the contract is that you're going to have the dog spayed and neutered within a certain time or at an appropriate time. That's usually part of it. That's part of most responsible dog owners. If they're selling a dog that's not spayed or neutered, they want that done.
One more question, Mr. Chairman?
Yes, sir.
Can we go back on that issue about how you get your money back? Say I buy a dog from you for $1,500, $2,000, it doesn't matter. Mm-hmm. And within 10 days or 7 days, whatever the contract is, I decide that dog just plain stupid and I don't want that dog. In my opinion now, I'm not saying the dog is, just my opinion.
Right.
How do I get the money back from you without having to fight you, like that Gamecock deal we just passed, or call the sheriff, or either call a lawyer and spend a lot of money?
I think you're going to have to treat it like any other contract. Now, under this bill, If you have taken the dog, it's not a question of you decide you didn't like the dog.
It's a lemon law for dogs, is what you're saying. Like a car, lemon law for a car.
That's right. With all the other law, all the other provisions of contract law still apply.
And in that contract, they say they'll return the dog, they can, if it doesn't, they can't. You kinda get what you buy.
Okay,
We're just trying to find good homes for dogs. For any other.
so in the previous version, Mr. Frank, I think you had certain criteria for being able to return the dog for a refund,
Right.
and it wasn't, one of them I don't think was that you thought the dog was stupid. It was health.
It was healthy, yeah.
It all, where's that enumerated? Does anybody see that?
Start in 179. Start in that section, in that area of 179. So I guess really it's probably 85.
And when shelters and others have paperwork on dogs, when they receive them and what has happened to them and other things, that would be part of the process.
It's all about a diagnosis.
Okay, who's on mic 10? Senator Goodman.
Thank you, Mr. Chairman. On line 101, I circled any known bite or aggression history. And then on line 122, I circled that provision that says returning the dog to the seller for a full refund of the purchase price and reimbursement of reasonable veterinary expenses. So we're dog lovers in our family. I've got a dog that sleeps in the bed with us every night, you know. But every dog that I've ever bought, every puppy that I ever bought would bite you. Huh? I don't think you, Mr. Chairman, but anyway. What'd you say? Yeah, yeah.
The dog and your wife.
The dog and my wife, yeah. And Jake. Yeah, Jake is our multi-poo. And, yeah, well, I'm just letting you know. So, but every puppy that I've ever bought would bite you. You know, that's just what they do. So I guess under this provision, and then if you sell a dog that is perfectly fine and somebody uses this and they carry it back and they want a refund, what about, you know, this person that is selling these dogs that's invested in that dog? They don't really know what's happened to that dog in the last 10 days that it's been in someone else's care. You know, and I know you can get a veterinarian to look at it,
Right.
but how do you know? You understand where I'm coming from?
I understand where you're coming from, and that's the balance we're trying to reach by saying within 10 days. You know, the longer you stretch that out, the greater the possibility maybe the dog's been abused. It's abused, and now it's much more aggressive. But at the same time, you want to have, you know, the time limit so that a veterinarian can look at it. And I think if the dog has been abused, for example, I mean, we do have our animal abuse law in Georgia. I think the person who is taking it back would likely try to invoke that or refuse to take it back with the old answer of sue me.
All right, thank you. I think we've got still, Mr. Chairman, a good many questions on this. It's a very important issue to the citizens of Georgia and to us on this committee, and we want to be sure we get it right. I do want to, so I want to suggest that we maybe look at doing a study committee over the interim to be sure we do get all these questions answered and get it right. But we do have a couple of people or one other person here that wants to speak to the issue, and we'll hear from her, and then we'll decide what the will of the committee is on that. Thank you.
Okay, thank you, Mr. Chairman.
All right, Tamara Feliciano.
Hi, good afternoon. Thank you for having me.
All right, and who are you with, Tamara?
I'm an attorney. I do work for a national animal welfare organization, but today I want to talk to you in my capacity as a Georgia citizen and an attorney who used to handle cases against pet stores, consumer complaints. And that's
Okay,
prior to my
Tamara.
current role.
We're happy you're here. We're gonna limit your comments to 4 minutes,
Sure.
please.
First of all, I just want to say I completely appreciate the intent of this bill. I agree that sick puppies being sold at Georgia pet stores is a problem that we need to tackle in this state. And I agree that there's a puppy mill pipeline entering Georgia, and these puppies are sick and they're being sold at Georgia pet stores every year. But where I disagree is the solution. Consumers actually have more protections without this bill than they do with this bill. And so that's why I'm here today to ask you not to move this forward. The Georgia Fair Business Practices Act and contract law covers almost any case a consumer can bring against a pet store if they are concerned about the health of the animal after purchase. And so there's no reason to instate a Georgia puppy lemon law that would actually cap consumer damages at the purchase price of the dog. I have talked to hundreds of consumers who had claims against pet stores, and I am not exaggerating when I say hundreds. And all of them have very similar stories, and one common denominator is that the veterinarian expenses are always going to exceed the purchase price of the dog. And so that is a big thing. I haven't had a chance to go through this bill. I've seen similar versions that had been introduced in the past. But if you have any questions, I'm here to help answer them if I can, based on my expertise.
Thank you. Any questions for Tamara?
Just a clarification, the consumer protection laws that you suggest would provide more protection for the puppy. What about for the puppy mill operator itself? Would it address the problems of the puppy mill operator?
No, none of this would. You know, the true problem is that if pet stores operating in the state of Georgia, and there aren't many that sell dogs and cats, if they wanted to stop selling sick dogs and cats and make sure that they're protecting consumers, they could just stop buying from puppy mills out of state tomorrow, and that would help. But in order to be profitable, they buy from dogs who are sick and who are being bred in cruel and inhumane conditions. So that's the real issue, and none of this is going to stop that.
Thank you.
Of course, that's your opinion. Senator, on mic 4.
Ms. Tamara, you say the laws are in place now that are more stringent than these laws here or to protect consumer. If that be the case, why are these laws being used to stop the puppy mills?
Well, I actually was involved in a class action suit against a pet store. We brought it in federal district court. The court said this is not the venue for this, and I'll quote the court. The court said, "The court is certainly sympathetic with Ms. Sinceros as to the loss of her puppy. If the allegations in her complaint with respect to the treatment of her dog by the defendant pen stores are true, they're an affront to all pet owners, pet lovers, and any standard of decency. Although this court concludes that the claims have not been stated a federal RICO cause of action, this does not mean she's without remedy. As previously stated, the facts may support additional state law claims for breach of contract and fraud. The reason that claim never got taken to state court for breach of contract or fraud is because of resources. Who's going to bring these cases? You're looking at lawyers who, you know, you have a consumer whose claim is $7,000 to $10,000. And as far as I know, I'm the only attorney that was handling these claims pro bono at the time. I went on to work for a different organization, and I could no longer take them. Animal Legal Defense Fund was actually representing the plaintiffs in this case, and they just didn't have the resources to fight these big franchises. So to answer your question is resources. I mean, it's animal welfare versus large corporations who have the money to litigate a case that animal welfare organizations just don't have.
Thank you. Yes, sir.
If this bill was passed, how would it, if we pass this bill, what would it take away from what's already there? If you can, if that's simple enough, I don't know.
It would cap consumer damages for one, which is a big problem, and it would legitimize what pet stores are already doing. By the way, pet stores are already doing all of these things. This changes nothing about the status quo. They're already sending warranties. They're over committing to vet records that aren't necessarily accurate. They're already doing this. So if you codify this, now you're legitimizing practices that have been found problematic in the past. And then this is going to control over your typical fraud and contract claims. And there have been states that have done that, and they've found a conflict between puppy lemon laws and contract law, and that has created a problem. California did it.
Now, we don't want to disparage all pet stores in this committee. There may be some bad actors, but I think it's unfair to say all pet stores are doing this and all of that. So let's not get out of hand with our comments here, please. Thank you very much. Appreciate you coming.
I appreciate it, and I didn't mean to be disparaging. I'm just telling you what I know based on my research. Thank you.
Thank you. Mr. Chairman.
Mr. Chairman, I'd like to make a motion to table Senate Bill 303.
All right. Got a motion and a second. We want to work on this in the interim and do a study committee.
Mr. Chairman, I would prefer that we just create a joint study committee out of this bill instead of table.
Okay.
So we move it across to the Senate, to the House. But again, a joint study committee regarding this issue, I think the lady was incorrect. I'm kind of to the breeding of the puppy mills is not the main problem. But, and there are not enough puppies in pet stores because of the process. We don't want puppy mills to be putting puppies in pet stores. We want better. But I'd appreciate if you would consider, instead of tabling it, just create a joint study committee out of this bill.
I'll rephrase it.
Well, so, Mr. Chairman, come up to the thing there, please. Just help me understand this. So we're up against the deadline for.
That's why I'll create a joint study.
If we do, you want to do a joint study committee
Yes, sir.
or just a Senate study committee?
A joint. If it's Senate, we can wait. But the joint would have to act now. And we could have however many the lieutenant governor and a speaker appoint and have a minority segment in there so we make sure we got a well-rounded.
All right, let me check with my counsel.
I don't want to be too much trouble
just
here,
a
but
minute.
just a little trouble.
All right, hold on a second. Stand by.
Is that good?
Please.
Standing by.
Joint study committee, and we are not, I wasn't planning on us meeting again.
You're gonna abandon me? Is that what?
We can just consider this a hearing only and continue to work on it. If you can,
Well, I will do a citizen study committee, but I was hoping to get that other group involved. But okay.
all right. So let me check with Chairman Anderson here. You want to withdraw your?
Yeah, I'll withdraw my motion.
All right, he withdraws his motion. And this will just be a hearing only on this bill, and we'll work on a study committee. But I think you are.
Yeah, maybe I'll have better luck with this next bill. It's a tough committee.
All
I
right.
even try to work with you.
Before we move off of 303, is that okay with everybody?
No, sir.
I know I probably didn't follow very good parliamentary
did good.
procedure, but
I appreciate
all right.
you.
Next, Senate Bill 572.
Thank you, Mr. Chairman. This is a vaping product directory, and this is also to tighten up the rules on vaping. I'd like to invite my friend Jennifer Cunningham come up here. She's not an expert witness, but she knows a lot about this issue. And she'll be here to answer the easy questions, and I'll take on the hard questions. My record on vaping, Mr. Chairman, issue is clear. Pro-regulation, and that was in the 2020 General Assembly session, passed the vaping bill, Senate Bill 375, which raised the age of purchasing to 21, taxed these products, and instituted license requirement. This bill is another pro-regulation, and you know, being a conservative, I don't like regulation of the business, but medical industry, we need to, and especially things like this and bad drugs and all that stuff. We need to make sure we have proper regulations to protect our kids and others for vaping issues. This bill creates a vaping product directory. A vapor product directory will provide transparency to retailers, consumers, and anyone who cares to know that what products are legal and being legally sold in our state. We're just trying to protect the consumer here. We can go much deeper.
Okay. Thank you,
Jennifer?
Chairman Mullis.
Okay.
Jennifer, give us your full name and who you're representing and your phone number,
Okay.
please, or I guess sign up on this thing. You don't
Sign-
have to give us your phone number in public testimony.
I'm happy to give it to anybody who's
I'll give you mine, though. Everybody else got it.
y'all took the sign-in sheet before I got here, but I'm Jennifer Cunningham on behalf of Jewel Labs, based here in Atlanta, Georgia. Really appreciate the opportunity, Chairman Walker, members of the committee, for the opportunity to explain why Jewel supports Senate Bill 572, and appreciate Chairman Mullis for introducing the bill.
Jennifer, excuse me, spell Jewel for me.
Juul
All right, and is there more to that name?
Labs.
Labs, Inc.?
Yes.
Thank you.
Okay. You know, before going into the merits of Senate Bill 572, we always like to share that our mission is to transition the world's 1 billion adult smokers away from combustible cigarettes, eliminate their use, and combat underage usage of our products. If enacted, Senate Bill 572 would establish a product directory for vapor products at the state level, as Chairman Mullis indicated, providing a critical tool for state and local law enforcement to ensure a responsible marketplace. A directory provides the dual benefits of helping to protect against potential health and safety risks from unregulated products and cultivating a responsible marketplace that allows the category to exist and provide adult smokers with legal alternatives to cigarettes, which is the #1 cause of preventable death in Georgia. The Vapor Product Directory would operate as an evolving list of vapor products that meet the U.S. Food and Drug Administration's criteria to be on the market and provide clarity to law enforcement, retailers, and adult consumers in determining whether a vapor product meets the state's criteria for being available in Georgia. Critically, the FDA provides extensive federal regulatory oversight of tobacco products, including vapor. The cornerstone of the FDA's oversight is the pre-market tobacco product application. It's a rigorous science-based process conducted by career scientists and technical experts. We believe the PMTA process is the appropriate forum to determine the role vapor and other innovative products can play to transition and completely switch adult smokers. However, states like Georgia can and should complement FDA oversight and support the PMTA process through a product directory. Certain vapor product manufacturers, including those located in China, continue to flood the U.S. market with products containing nicotine from any source that ignore or design to evade the regulation by the FDA. These unregulated products may present additional health and safety risks to adult consumers and undermine underage prevention measures. The harm reduction potential of our product and category will only be realized if we have a well-regulated marketplace that provides adult smokers with access to responsibly manufactured products while preventing underage use.
Hey, and also, as Jennifer said, a lot of the problems are that we're receiving these vapor products from all over the world, especially China, and they don't go by our regulations, and we never know what's in the product, and this somewhat helps govern that and make sure we have safe products. Alabama and Oklahoma has already passed this type legislation, and this year Maryland, Mississippi, South Carolina, and Tennessee are considering this as well. Their session goes a little later than ours, though.
But, so that was the end of my testimony. We just asked for your favorable support of Senate Bill 572. I'll try to answer any questions to the best of my ability.
Yes, sir. Thank you, Mr. Chairman. Thank you all. So this would tie all vaping products to the FDA's pre-market tobacco product application. How many companies have current FDA approval to create vaping products?
So they've only, I believe, I checked the numbers this morning, I believe they've only approved 8. There's many more pending applications that are still under review, but they've also done a lot of work by way of issuing I think like over 1 million denials. So it just, a directory would be able to provide visibility to those that, they would not be able to attest if they received a denial. So it's just right now, be an effective enforcement tool to check that as well.
Another question? So what would happen to our current vape shops who are selling vape pens, vapor products that are not selling one of the 8 regulated or FDA approved vapors?
Yeah, so you're still able to sell the product if your application is currently under review, as long as you were selling the product by August 8th, 2016, which was a date that was created by the FDA. And I would just think that there will probably be people that can better speak to why about what would happen to the vape shops if they are not undergoing the FDA process.
But again, Senator, we're trying to make a safe product and them to sell a safe product, and with all the bad players in the world, we don't think that's going to continue to happen. So this bill would help that.
Senator Summers.
Thank you, Mr. Chairman. Talk to me about the age deal on this again. Make sure it was 18 and now it's 21.
That's correct. 2 years ago.
Personally now, I'm going to be very candid with you. I don't have any problem you get rid of all of it. Okay, you can ban the whole crap all I'm concerned. But I have people that call me and tell me this is just what these young people want to do it. They're going to find a way to do it. And they're going to get some 21-year-old to go buy it for them. We're sort of in a little ambiguity here in regards to how we can police this right here, because the young people, I had 2 young people call me over the weekend. Now, I don't know how these people knew about this bill until somebody told them, because I didn't know about this bill, But the point was, it says, Mr. Carden, he said, if I'm old enough to sign up and go die for my country, I'm old enough to go get what I want to get, whether it's beer or whether it's vaping products. Now, how do I deal with that?
So this bill doesn't actually do anything.
I know, but I'm just saying
okay.
It's 18.
Well, so the raising of the purchase age was first done at the federal level, and then it just was for states to be able to enforce the raising of purchase age. That's why you saw individual states pass
So
their
what
own
I'm
legislation.
saying is now, when somebody goes and buys it for these young kids, where do we go from here?
That I don't have the answer to.
I would recommend you drop a bill to change the age back to 18, and for the drinking too.
What about can we speed? Can we make the speed limit a little higher?
If you want to. Look, we're lawmakers, not law enforcers.
Thank you.
Yeah.
I'm concerned.
Thank you, Senator. I'm for it.
Senator Goodman.
Thank you, Mr. Chairman. I would have assumed that in order to sell vaping products that you would have had to the only way that you could do it lawfully was that it would be something that had been approved or had, you know,
Yes, sir.
some kind of go-ahead from the FDA. But how widespread are these products being sold that have no FDA approval and haven't?
So I don't have exact numbers, if you will, and you know, the term pre-market tobacco authorization would definitely is counterintuitive that you would have to get that beforehand. But like I said, as part of the FDA framework, the 2016 date was something that they established that if you were on the market then, and as long as you filed by the September 9th, 2020 deadline. But there's just, if you just, you know, cared to do your own kind of research and looked at what was all, you know, available right now, I think you'd be able to draw your own conclusions about that.
Here, there are vape shops all over my district, and they're practicing by the law and the law that we create here. Again, we're just trying to protect the consumer a little more.
Senator Jackson, one more question, and then we'll move to the people that have signed up.
Yeah, Senator Mullis, Mr. Chairman, thank you so much for trying to keep us healthy and safe. My only concern is I've gotten a lot of emails from people who run vape shops, both in my district and yours, and all of them have expressed great concern that this would limit their ability to sell and maintain their stores. The language that they're talking about is it would decimate their shops, and so I'm just curious, have you heard from your own vape shop owners about this? And
I may have, but I'm not aware that I have. I mean, I hear from every bill that goes through this building. However, you know, I want them to be profitable and I want them to be successful, but I also don't want them to sell vape products that are prevented or presented by bad players. And maybe we should make sure the whole industry would want to make sure that their consumer has a good product, and I don't know if we can do that with some of the vaping products that we get overseas.
thank you.
All right, Senator Burns, and then we'll get to the testimony.
Just a brief comparison, Mr. Chairman. If I sell tobacco products, must those tobacco products be legally identified?
Yes.
So I can't sell a non-regulated tobacco product. Is that correct?
That's correct.
Okay. So a vaping product.
It's got that sticker on it.
It's got that sticker on it about the Surgeon General, among other things.
Mm-hmm.
And I'm totally opposed to tobacco use. And I'll be candid and tell you I'm personally totally opposed to vaping use. However, your intent, I believe, is to control the quality of the product that's legally being offered. Is that correct?
That is correct.
Thank you, Mr. Chairman.
Okay,
Thank you.
All right.
We'll step back.
Thank you. We've got Angela Holland is here to testify with the Georgia Association of Convenience Stores. Welcome, Angela.
Thank you, Mr. Chairman and members of the committee. My name is Angela Holland. I currently serve as the president of the Georgia Association of Convenience Stores. We represent large chains as well as small multi-generational family owned and operated locations. And so we appreciate the intent of the bill and working with the bill sponsor to hear our concerns. And we've been assured that they will continue to work with us as the bill moves through the process to hear our concerns, but we currently support the bill.
You do support the bill
We do.
in its current form?
I don't believe I have seen the substitute today, but we have talked about issues that one of the issues we had talked about was the date issue, being able for the retailers that currently have product to be able to get rid of that inventory.
Okay, thank you. Any questions for Angela? Thank you, and thank you for being brief. Gregory Conley with the American Vaping Association. And Gregory, we're getting into some other people's committee time, so if you would keep your comments succinct, please.
I will try my best, Mr.
Yes,
Chairman. Mr. Chairman, members of the committee, my name is Gregory Conley. I am an attorney from New Jersey. I have been working on regulatory issues around vaping, including the FDA PMTA process, for about a decade. So I'm glad, I know we have a time limit, to ask any questions about this very complicated process. But ultimately, I'm here today to encourage you to vote no on SB 572, because as the phone calls have said that have come into your offices, this will decimate a 3-digit number of employers here in Georgia, not because they are doing anything wrong. None of the vape shops are selling illicit vapor products filled with drugs. Those are illegal products. They are sold by drug dealers on the street. Nothing in this bill addresses that. Instead, what it does is that while this bill may have been pitched, perhaps to the sponsor, as an industry-friendly bill to tamp down on illicit or counterfeit vaping products, what it really is a wolf in sheep's clothing. Illegal drugs are already illegal. And instead, what this bill does is it ties Georgia's regulatory policy on all vaping products, including nicotine-free products that don't even contain any nicotine and can't be regulated by the FDA. You're banning nicotine-free products like that just because the FDA does not have federal authority to regulate them. You're tying it to a molasses-like politicized regulatory process at the FDA. I'm sure all of you have one area of federal law or a federal regulatory agency where you look at it and you say, how can they be so inefficient? How can they not get this? That's the FDA, unfortunately. Over the last 6-7 months, the FDA, after for years telling small businesses, you can get through this process. Believe in us, we are working on reforms. Well, the FDA took over 1 million applications, the vast majority of which from small business owners like the ones in this room, and they just denied hundreds of thousands of products, giving no options. And to correct a statement earlier, one single product has been authorized by the PMTA process. The product is 5 years old. Nobody likes it. It has about 1% market share. So one single product, 1% market share. That's the only thing that's authorized today. None of these vape shops can survive selling one product, or if we get to 5 products. So what these companies have done is that in response to the FDA, there are about 36 federal lawsuits pending in the various courts of appeals. We have faith. We have already had 2 court of appeals hearings on these bills, or rather the FDA policy, and we had judges that looked at the FDA and said, what are you guys doing? So we anticipate that it's going to take time, but that the rulings by the federal courts will eventually lead to the FDA saying, we need to fix this process. In the meantime, the businesses are not selling products that have been denied by the FDA. Instead, they've switched over to tobacco-free nicotine, which eliminates impurities that are present in tobacco-derived nicotine, as well as selling nicotine-free products. And to repeat, you all want, the goal is to get people off of nicotine. Well, here's the problem. The FDA is only allowed to regulate products containing tobacco-derived nicotine. So all the nicotine-free products that people use to get off, to stop vaping entirely, to do the good thing, those will be instantly banned. Now, I've already taken up too much of your time. I'm glad to answer any questions. You should not have to become experts on a very niche area of federal regulatory law mid-session to understand whether or not a bill you're voting for is good or not. Please listen to the small business owners. Thank you very much.
All right, thank you. There's a couple of questions, if you don't mind.
Yes, sir.
Senator Sims.
Thank you, Mr. Chairman. Sir, did the vaping shops understand the FDA's process or regulations before opening their shops? Or did they open the shops without those regulations being in place because they thought the regulations would come afterwards?
That is a great question. The vast majority of the business owners, the people who are really dedicated to helping the smokers quit, they really started opening their shops 2013, 2014, 2015. The FDA regulation did not take effect and didn't really come out until the summer of 2016. So these small business owners, they got into this, all of them, virtually all of them, with the right reasons. They want to provide a product to get smokers off of cigarettes. But then the FDA came along, and after years of saying, we are working on fixing this process, we know it's a process designed just for big tobacco companies that have millions and millions of dollars to spend. The people behind this bill admitted they spent $100 million on their 2 PMTAs, $100 million. None of these businesses can afford that, and to answer your question, none of them expected that it would cost $100 million just to maybe be able to stay in business.
Mr. Chairman, a follow-up statement, not a question. Well, maybe a question. Do you think these are prudent business people to open shops without having the right information or anticipating that this may happen?
So many of them were aware, Senator, that the FDA was eventually going to come into this market. But if you follow along and watch FDA video conferences, which I'm sure all of you do, the FDA repeatedly over the years has said, Small businesses should not panic. Small businesses will be welcomed into this process. We are going to reform the system. We don't want to see these vape shops that are dedicated to helping smokers quit. We don't want to see them close. And then unfortunately in the last 18 months, in the haze of COVID, where you can't even go to the FDA and have a meeting, the FDA has just abandoned all of that.
One more.
Did you actually use haze in part of your testimony? It's very good.
One more follow-up.
Purple haze. Go ahead. Yes, ma'am.
Quick.
Those are only sold on the street.
You say that most of them open to help smokers quit smoking.
Correct.
I don't agree with that. I think it was totally to make money, and that's all I have to say.
Thank you. All right, Senator Goodman.
Yes, sir. I'll be quick. I've got a 17-year-old and 14-year-old sons. We go to all the ball games in Athens, and I've been downtown to see all these young people that vape nowadays. I just want to make sure that I'm understanding this correctly. Are the majority of the products that are being sold in these vape shops, have they not passed some sort of regulatory approval to be on the market to ensure the safety of these young people that are using these products?
So first, good news is that in the last 2 years, 2019 to 2021, we saw a 60% decline in youth usage, middle school and high school usage of vaping products. We need to do more, but we are seeing progress. And second, for the products, the hundreds of thousands that the FDA denied, all of those product manufacturers have, for the last 4 years, had to submit their ingredients list to the FDA, have had to have their manufacturing facility registered with the FDA. So all of these businesses that were selling to the Georgia vape shops, as well as the Georgia manufacturers, they were doing the right thing. If the FDA ever identified an ingredient that they thought was hazardous to human health, they could have issued a rule saying that ingredient can't be in.
I understand, but the thing that concerns me is that they have not been approved. I mean,
They have not been authorized, but there are all new age nicotine products, including nicotine pouches that are sold at every convenience store in Georgia. Those products do not have PMTA authorizations. They are pending, just like many of the products that could be banned. So yes, we think that in 3 years' time, 2 years' time, we are going to have the FDA actually regulating all vaping products, and it will be partially because of federal judges saying that the way FDA reviewed these applications was illegal. But these businesses can't operate selling one single product with a PMTA for the next 2 or 3 years until we actually get the political and judge pressure that's necessary to do that. And I'll just also note the Oklahoma bill that was mentioned earlier as the only PMTA registry in the country. We just got a bill passed out of committee Monday, or rather Friday of last week, to delay that at least 2 years, and it might actually be 3 years. So the Oklahoma legislators, they passed that in secret, very quietly last year in the middle of COVID, and they heard from the business owners with the exact same concerns you're going to hear, and they just passed a bill for at least a 2-year delay.
I'm just surprised that I'm a farmer, and so we have to have FDA-approved chemicals to treat our crops. And I'm a little surprised that to be quite honest with you, because this isn't an area that I deal in very often, but I'm a little surprised that we have products that are not FDA-approved that people are allowed to put in their bodies. But yet, as a farmer, I have to use FDA-approved ag chem products. That's just surprising to me. Thank you, Mr. Chairman.
Senator Rahman.
A quick question is that, do you know how many, you said that thousands of stores, but do you know how many stores we have in Georgia?
One of the people that will be following me will have a better estimate, but my feeling is that it's about 200 stores that would be at serious risk of closure. I know that just in northern Georgia and the sponsors district alone, there's 3.
Okay. All right, Senators. Yes, sir.
You said some study about 60% decrease or 40%.
Yes, sir.
Who did the study?
Senator, that is the National Youth Tobacco Survey. So not the industry, that's the CDC. The CDC every year does the National Youth Tobacco Survey as well as the Monitoring the Future study. And it was the National Youth Tobacco Survey that found a 60% decline. And that was after all the decline started after Federal Tobacco 21, as well as after Juul was forced by the FDA to remove certain of their vaping products from the market. We actually did see youth usage fall, and now the very same company that propelled the youth usage epidemic now wants to shut down the stores that do not have a significant youth problem. Just don't understand it.
All right, we've got 2 more. No, 1, 3 more people here to testify on this. So one more question for you, and then we'll move on to the next. Senator Summers.
Thank you, Mr. Chairman. Quickly, I agree with what Senator Sims said. I think it's all about money. I don't think we've come down what Senator Goodman said. I see people vaping every day in the parking lots, at ball games, everywhere you turn. It's overloaded. The question is, you're telling me that the federal courts, you believe, will come up with a ruling on soon. So if this bill had some kind of formal, like 2-3 year sunshine in it, whatever, would that be something that could be worked with to be able to get us to where we need to be? Because I agree with Senator Mullis, we've got to do something to make sure we get the thing.
So if the bill, a sunset would be inappropriate because a sunset would say July or September would come, depending on what language gets used, and all these businesses close. But if you followed the Oklahoma model, which is going to pass this year most likely, which is, yeah, we created the PMTA directory, but this is such a mess that we're going to delay the actual implementation date till 2024 or 2025. That'd be different. That actually would give these businesses time. It would allow them to continue to operate, but just the sunset in a couple of years, that would have the opposite effect. That would just close them down. Hope I was clear.
All right. Thank you, sir.
Thank you, sir.
Next, we have Susan Stutzman, Georgia Vape Alliance.
Hello.
Hey, Susan.
Thank you for allowing me to speak today. I'm a little bit more nervous than Greg, so bear with me. All right. Dear members of the Senate Agriculture and Consumer Affairs Committee, on behalf of GVA, Georgia Vape Alliance, which promotes tobacco harm reduction through the use of non-combustible nicotine delivery products, as well as a small vape shop owner myself, I am urging you to oppose SB 572. If this bill passes, shops like mine and others throughout Georgia would be forced to go out of business. In 2021, the industry created 1,868 jobs directly related to the vape industry. That was to answer one of the questions when somebody was asking how many vape stores there were. These jobs generated more than $66 million in wages, as well as hundreds of secondary jobs to our great state of Georgia. Bringing the total economic impact in 2021 to $540.5 million. Georgia received more than $31.2 million in state taxes, all due to the vaping industry. These numbers may sound good, however, that is actually down by 16.1% from 2018, where our economic outpost was $644.3 million. So we have already seen dozens of shops close and go out of business, and vape-only shops have decreased by over 30%. The FDA has not yet designed a fair application process for small businesses, despite promoting to do so in January of 2020. The current administration and the FDA decided to kill small businesses instead of implementing a PMTA reform for small applicants. A synthetic ban only helps large tobacco companies exist. Shops would not have any product to sell while awaiting the outcome of the lawsuits of the FDA are currently facing the court system, and which we believe would be overturned to our favor. This would result in more shops closing prematurely without knowing the outcome of these appeals or lawsuits. A tremendous tax loss to the state of Georgia, as well as hundreds of our citizens becoming unemployed. The legislation would also allow only the sale of products that are more likely to be sold to minors during the FDA compliance checks. Of the 98 products that were sold to minors between December 2021, 73.5% of those products were e-cigarette products, including Blue, Juul, and Views, which would still be permitted to sell products in the state. In speaking with my customers, they do not want to vape just Juul or Views, which hook millions of kids on vaping. My adult customers want alternatives that are sold in vape shops and not just convenience stores. If I do not have option for my customers, they would probably return back to smoking, or worse, buy off black market. This is a bill that protects the companies whose products are the top selling to kids. In conclusion, I would plead for you to oppose SB 572. My shop has been in business over 10 years. It's not about the money. It's the best feeling of selling and getting somebody to quit smoking. As a former smoker, I'm 7 years tobacco free. And I would like to continue to remain open for the next 10 years. My business also provides, I talk to our sheriff's office, I donate to Cups for Kids at Christmas. It's not just about the money. I used to be corporate America, was a stay-at-home mom, and found something that I could do as well as help. It's a great feeling. With that, I thank you for your time and try to answer anybody's questions.
Thank you, Susan. We're going to move on to Keith Gossett. And Keith, like the others before you that have come before you, would you just keep your comments sort of brief?
I promise you I will, sir. Good afternoon, Senators.
Good
Thank
afternoon.
you for having me.
Now, who are you with, Keith?
I am Vice President of Georgia Vape Association. I own Bucky's Vape Shop in Columbus, Georgia. I will keep this short. I didn't prepare any notes, mainly because I can't read my own writing half the time. I've got 4 points of concern with this bill. Number one, it's going to shut me down. Pure and simple, this bill will close my shop. I've been open for 8 years. I have a customer base well over 8,000. The second point of concern is it's going to send my employees, all of which are my family members, to the unemployment line. They have been in my shop since day one. Most of the people that come into my shop ask for them by name, and they know that when they come to my shop, they're going to get personal service, they're going to get their questions answered, and they're going to get a product that is safely made in a controlled environment and not off the black market. My third point of concern, you folks just started getting taxed from us, and now you want to give it away by closing my shop. I'm dumbfounded by that. I really am. That brings me to my fourth concern, and this scares me. This bill is going to create a black market. I know that the sponsor of this bill would like to think that he's going to eliminate counterfeit or black market products. It ain't going to happen. It's going to create a black market because I just told you I have thousands of customers. They're accustomed to the products they're getting that keeps them off cigarettes. They're not giving it up. They're not going to just go to Juul. Juul has 50 milligrams of nicotine in it, and the product they're buying from me has 3. They are getting 17 times more the nicotine from those products than they are in my shop. They come to my shop because of that. I give them the ability to, I don't want to say control the amount of nicotine that they get, which I guess they are, but it gives them the opportunity to lessen the amount of nicotine that they're taking. It gives them the ability to diminish that to 0 if that's what they choose to do. And we've done it with 1,000 customers. We've got them to 0 and they walked away. So my fourth concern is, what in the world is this bill going to do when you start making criminals out of my employees, out of my customers? What about Mary Jane that knows how to put 4 ingredients together in the musty old corner of her basement and sells it to all her friends at a bridge club? Who's going to go and tell them that this bill wasn't supposed to make that black market, but we did? We're sorry. I have products in my shop that have been innovated over the years to include safety features. Prior to 2016, we didn't have all those safety features. We had things that we made. I can make you a box mod in about 15 minutes from parts I can get from Home Depot and batteries out of a laptop. People know this. They're not doing it now like they did back then because they don't have to. They come to my shop and buy a safe product. They don't have to buy that stuff. But you take it away from them with this bill. And I'm not saying you want to. I'm begging you not to. But if you take it away from them with this bill, they will make these products. You're not gonna stop a black market. You're gonna create one. When your neighbor's 15-year-old football star son goes to the hospital with his fingers burned off because he used a box mod that his buddy made from Home Depot and a broken laptop, you can thank this bill. That's what I've got to say. Thank you for listening to me.
Thank you, Keith. Lisa Gano.
Afternoon. My name's Lisa Gano, and I'm here on behalf of, I've got Vape Right is a retail stores, and we've got 5 stores. We're in Fulton County, Cherokee County, Cobb County, and Bartow County. I also own VR Labs, which separated from Vape Right in 2016 and manufactures the e-liquids. So this bill has got 2 companies that it will put out of business because when the FDA issued its market denials, I had 100 different flavors. Only 9 of them are still active. And this is because they had the word tobacco or menthol in the name. I have many that are still tobacco or menthol, but were denied because they didn't have that in the name. I have, of those 9, I have one example that is salted caramel cream tobacco. Obviously a flavor, but it's still okay because it had the word tobacco in it. There was no rhyme or reason. It does not make any sense. But with only 9 flavors out of the 100, I'm not going to be able to stay in business. I know that over 60% of my consumers want fruit flavors. So the only way for me to help them is to use the tobacco-free nicotine, which is what I've been doing. I do not sell, I do not manufacture any of those flavors that had market denials. Those have been set aside. But if this bill passes, I will be out of business in both my companies. All 26 of my employees will be unemployed, and I'll have to figure out what else we're going to do. We started this company in 2009 with my husband, who was smoking 2 to 3 packs of cigarettes a day. I was teaching school. I love teaching. I taught for 17 years. But I wasn't making enough money for him. With the recession, his business had gone out, and he's smoking 2 to 3 packs a day, costing at that time $300 a month. He tried everything, acupuncture, the patch, the gum, medications, and he could not quit smoking. He got an electronic cigarette, and he quit smoking that day. That's what started this business. It wasn't the desire for money. It was the desire to get people off cigarettes. Yes, we do need to make enough to support our family, but that's the only reason. Without this, if this bill goes through, you're pushing so many people back to cigarettes that we know kill people every single day. The best thing is clean air for anybody to inhale. I agree. People don't need to smoke cigarettes. It's better if they don't vape. I agree. But if you're looking between smoking and vaping, vaping is the winner. I'll stop.
Okay, thank you.
Thank you.
Mr. Chairman, you want to close it out?
Yes, sure. Well, Mr. Chairman, the gang of people who are not happy with my bill has never once come by to see me. I have worked with Angela with the Convenience Store Association and, of course, Jennifer, but I've never heard from any of these people, and they've never come by. I would prefer to move this forward, be glad to work with people as we get through the crossover and see if we can come to some terms with them, but we're at the point I need to move this forward. So I appreciate that.
Are you number 5?
Yes, Mr. Chairman. I make a motion to pass on LC 365284S.
All right. Got a set motion and a second. Further discussion?
Mr. Chairman,
Yes, sir.
I'm afraid that I'm looking at this thing here. I want to help Chairman Mullis, and I want to get this thing done. There's got to be an answer here, but is there any way the Chairman Mullis would consider a study committee on this to let us know a little bit more about what we're trying to deal with here? Because I don't want to put anybody out of business. I know that's not your intent either.
No, but the process here is long even from here. about moving forward through the rules and on the floor, and then going to the House for even more discussion. So I would rather move it forward at this point. We've had a study committee already today, and I appreciate moving it that direction.
All right. Thank you. Motion is second. Any other comments? Mr. Chairman, if this were to move forward, would you be open to delaying the implementation so that
Sure,
people that have invested their livelihoods in these stores?
Sure, but
would have-
it is kind of interesting, according to Senator Sims' question, that they open the stores without the regulations, and I would suggest that FDA is on the way with even more. So I'd be glad to delay the beginning of this, and through the process, we can find the right temperature here.
Yes, sir.
Mr. Chairman, if you're amenable to that, would you be open to an amendment to go ahead and do
Certainly.
that now?
Absolutely.
Well, I think the only place that would be impactful, if I'm going to direct my comment to Legislative Council, that'd be on line 12. Would that be the only place, Dave?
Looks like 29 and 37. Two.
Mr. Chair, there are quite a few dates throughout the bill. So there's a whole, range as it goes. There's line 12, September 1st, 2022, line 29, December 1st, 2022, line 37, January 1st, 2023. We could just change all of those, maybe back 1 year each or 2 years each, with whatever the will of the committee is, but we would want to change all of those, I assume.
If you did a year, you'd be able to change anything you saw coming forward that was problematic. Or
So I would, Mr. Chairman, if it's able, I'll make a motion to amend.
Y'all have chaired more stuff than I have.
So there is a motion, you can actually amend
Amend
at
it
this
now?
point. You can
Okay.
amend it now. Yes, sir. You can either amend before or after, so we're in a
Okay.
posture to amend.
Go ahead with your amendment.
So, with that, Mr. Chairman, I would, make a motion that we amend line 12, from 2022 to 2024, line 29 from 2022 to 2024, and line 37 from 2023 to, 2025.
All right, got a motion on the amendment. And a second. Any discussion on the amendment? All in favor of the amendment delaying the implementation of this bill, raise your hand. Any opposed? All right, the amendment passes. Now, we will, we've got a motion and a second on to do pass Senate Bill 572 as amended by committee to create a new committee sub. Any further discussion? Seeing none. All in favor, do pass, raise your hand. Keep them up now. One, two, three. All right. All opposed? Okay. All right.
Thank you, Mr. Chairman. I
Passes.
appreciate it.
Thank you. Yes, sir. That's all we have today, and we'll stand adjourned.